Tonight, the entire episode is devoted to the Supreme Court's order that names of foreign account holders given to the government by various countries should be handed over to the court. As yet, the names have not been revealed, but given to the SIT in a sealed envelope. The SIT will now decide what to do. Prashant Bhushan, however, has already said he will petition the SIT to make the names public. In addition, it's possible they could leak, particularly if they're shared with agencies like the Enforcement Directorate and the CBI. So tonight we ask, if the names are made public or leaked, how serious could be the consequences for India? In part 2, I shall talk to two leading lawyers, Harish Salve, who is sharply critical of the Supreme Court's action, and Prashant Bhushan, who petitioned the Supreme Court in the black money case. But first, an exclusive interview with Attorney General Mukul Rohatgi. Yesterday, he faced the ire of the court and was virtually told the court is not concerned with the confidentiality clauses India has signed up to. How does he respond to what the Supreme Court has done and what the Chief Justice has said? Mr. Rohatgi, this morning the government handed over to the Supreme Court in a sealed envelope the names of 627 people given by HSBC Bank. Why have you not submitted the 612 names which the press has said have been given to the government reportedly by the International Consortium of Investigative Journalists?
Karan, the government of India got from the government of France a list of 627 names which emanated from HSBC Geneva, which had been stolen by an employee in Geneva. But we got it from the government of France based on double taxation avoidance treaty, which has a clause of confidentiality and so on. But the answer to your question is that what was required by the court and what is being investigated by the SIT are these 627 names. There is no authenticity whatsoever attached to the list of some 600 names from an organization which you have just mentioned, and therefore what is in contemplation are these names, and these names are undergoing a verification and an inquiry, because some of these accounts may be genuine and some of these may be legal, some may be illegal.
Let me ask you a quick question before I move on. Does the government have names from other sources which you have not shared with the court because you don't believe they are authentic or verified?
No, let me tell you, you must understand the parameters of this kind of an investigation. Just for information, one of the three names which were disclosed day before yesterday was a name which we had got from another government and which did not occur in the list of 627. So it's not only that we are getting 627 names from one government, we constantly get information from different governments. That is also verified. It's an ongoing practice. There are lakhs and hundreds of entries of transactions which are passed on by some governments, which are verified. In many cases, even students opening accounts in England and so on and so forth are informed. Those are routine, they are seen and they are junked.
Let me put this to you.
Therefore, the one particular name we got.
Please finish, go ahead. One particular name you got, please finish.
One particular name we got, as I told you, was from another government under another treaty, which is called, the type of exchange of information in that case is called spontaneous. Which means that you don't need to make a request. Spontaneous means that if those tax authorities are suspicious of one particular account because of huge withdrawals, etc., they tell us.
Mr. Rohatgi, let's not get lost in technical details. I wanted to actually clarify a specific point, and let me put it like this. Newspaper reports claimed that the Chief Justice had asked for all names given by all countries and all sources to be made available. Was that the case, or were newspaper reports inaccurate?
The reports are inaccurate. The Chief Justice asked for names from Germany, which are famously called 26 accounts from Liechtenstein, and the list from HSBC. There are no other lists except these two. The first one has since been made public in the month of May 2014, pursuant to orders of the Supreme Court. The second list is the one which is engaging the attention of the court, the SIT and the Government of India, and that list along with an updated status list or a status report for these 627 were placed before the Supreme Court in a sealed cover today.
Now the Supreme Court has handed the names to the SIT in that same sealed cover, but what assurance do you have that the SIT won't make the names public? Prashant Bhushan, one of the petitioners in this case, has gone public today to say that he will petition the SIT to make the names public. So I repeat, do you have any assurance that the SIT won't make the names public, or are you worried they may?
No, we have no assurance from anybody, but if he makes that plea, as we have said, these names were with the SIT from 27th of June. So they will get a duplicate list through the Supreme Court. We have nothing to hide, but we will request the SIT not to disclose all names because they will be in breach of the confidentiality clause of almost all double taxation treaties, and the treaties provide that once the investigation is complete and you have separated the grain from the chaff, namely that such and such accounts are tainted and are having ill-gotten money, then those accounts can be declared in a tax court, which means public, and therefore they should be made public. The right of privacy of genuine account holders should not be made public. That is the treaty.
I understand.
And that is the judgment in Ram Jethmalani case itself.
Let me interrupt you. I understand all of that. What I want to ask you now is a very specific question. The names will also, it seems, be shared with agencies like the Enforcement Directorate and the CBI. What is the danger that they could leak? You know and I know that the Enforcement Directorate and the CBI is notorious for leaking.
Now, Karan, I cannot say whether it will be leaked by one department or the other, but presently the list is with the SIT. In fact, from June till now, till the end of October, they have not been leaked. The SIT is a very responsible body which has drawn officers from various departments, and I am sure that they will take all steps to maintain secrecy as required by law and declare names as required by the treaty as and when the time comes. But one more very important question, one more very important reason I must tell you. The income tax is bound to complete investigation and all assessments under the Income Tax Act for undisclosed income by 31st of March 2015 for all these accounts, because the limitation will run out.
Absolutely.
Therefore, it is not open-ended and it will end in 4 or 5 months from today, and you will know what the truth is, what has to be disclosed,
Mr. Hodgkin, I'm asking you specific questions. Give me specific answers, please, sir. The problem is, you are confident and hopeful, but you have no guarantee that the SIT won't make the names public. Let me, on the other hand, point something else out to you. When yesterday in court you stressed the importance of confidentiality, the Chief Justice actually scoffed at it. He said, and I'm quoting, "Don't give such certificates of confidentiality." He then added that the court would deal with any problem arising out of breach of confidentiality whenever it happened. And I put it to you, that's not a very reassuring indication from the Chief Justice of India. That worries people. It suggests that, in fact, if the SIT were to make the names public, he wouldn't stand in their way.
Your assessment, I respectfully say, is completely erroneous. First thing everybody must understand is that exchanges in open court between the bench and the bar do not constitute any view or a judgment of the court. The judgment of the court is what is written on paper. Every day we have exchanges in all kinds of cases. That does not constitute any law or any verdict or any directive. So if the press chooses to just write all the words which were exchanged in court and put out all sentences as if that is the verdict of the court, it is completely wrong, and completely wrong on the part of the media to say that the court has already taken a decision.
I accept your point that the obiter dicta of judges, which is their spoken comments, can't be taken as their written judgments, and therefore you don't have to take them as seriously as perhaps the press does. I accept that. But the problem is that we at Headlines Today have very good reason to believe that you may already have breached the Swiss double tax avoidance agreement. We have a written communication, Mark sir, a written communication from Anne Cezard of the Department of Finance of the Swiss government in Bern, which explicitly says, and I'm quoting her, the information exchanged under the terms of the DTA can be provided to a court in situations where it is dealing with a specific case related to tax matters for which this information is relevant. Then she adds, conversely, information cannot be disclosed in principle to a court or any other body outside of such proceedings. Now, you've released names that are not connected to any specific case. Secondly, none of those names face cases. So I put it to you, you may already be in breach of the Swiss double tax avoidance agreement.
Whether we are or we are not is a separate question. We are bound by the judgment of the Supreme Court to give all names in a sealed cover to the SIT. The SIT will maintain confidentiality, and we have pleaded before the SIT that we ought not to be in breach of any confidentiality clause, and that is exactly what I was putting before the Supreme Court yesterday, but the ultimate occasion did not arise for the Supreme Court to give any verdict.
You had a
This is where we stand, and we will...
You began your answer
explain to the Swiss authorities.
Attorney General, you began your answer. Attorney General,
we are also bound.
Attorney General, you began your answer in a very telling and revealing fashion. You said whether we are or are not in breach of the Swiss DTAA is another matter. You're therefore clearly conceding by implication that you may have already breached the Swiss DTAA, as Anne Cezard's letter clearly suggests you have.
That is not true. I have not seen the letter, and I cannot really deliberate upon it. The letter is addressed to maybe to the income tax authorities. It hasn't come to me. But one thing I must tell you, that after the Supreme Court directed 8 genuine accounts also to be disclosed from Liechtenstein in the month of May 2014, we got a letter from the German authorities as to why they have been disclosed, and we are supposed to give an explanation. We don't want a repeat of that situation, and that is why we went to court yesterday.
You've said something very important. You've already received a letter of objection from the German authorities for disclosure of information and details to the court which they believe you should not have done. Now I'm saying to you that Anne Cezard has communicated to our channel to suggest that the information given to the Supreme Court this morning may be a breach of the Swiss double tax avoidance agreement. Let me put this to you. And I'm asking you this question as Attorney General and as one of India's most learned and respected lawyers. In terms of the double taxation avoidance agreements, how serious a breach is the breach of the confidentiality clause?
I will answer it in two parts. First, giving documents in a sealed cover to a court which ultimately did not even open the sealed cover and passed it on to the authorities concerned cannot be deemed to be a breach of the confidentiality agreement, because the court did not even look at it, number one. Number two, if a breach actually occurs and we are unable to give a satisfactory explanation to the reciprocating court, then it is possible that that reciprocating state may either refuse to deal with us and give us further information, but certainly information will dry up, and our concern is that if information dries up, the question of unearthing black money abroad will become absolutely impossible, and in fact it will be counterproductive to Mr. Ram Jethmalani's case. This is what I wanted to explain to Mr. Jethmalani and to his lawyer.
I'm particularly interested in the second half of your answer, that if you are deemed to have breached a double taxation agreement by breaching the confidentiality clause, collaboration and cooperation will stop, information will dry up. On your first point, that because you gave the information in a sealed envelope, it can't be considered breach of confidentiality. I just want to remind you of what Anne Cezard of the Swiss government has said. She says information cannot be disclosed in principle to a court. It has to relate to a specific case. You've given names in principle. They don't relate to a specific case. Therefore, as far as Anne Cezard is concerned, you have breached it.
I'm sorry, your contentions on both counts are wrong. Firstly, there are 627 specific cases. Secondly, giving something in a sealed cover which cannot be seen by anybody cannot be termed as a disclosure. And this, if no response has been given to this letter, as I told you, I'm not aware, then I will draft this response the way I am telling you and the viewers, and we will contest the fact that there is a breach of the Swiss Treaty.
Let's move on. If you are deemed to have breached, the confidentiality clause in the Swiss case or the German case or the French case, what impact will it have on the additional double taxation agreements that you are presently negotiating? I believe you're negotiating some 7 or 8 agreements with 7 or 8 countries. You are also involved in negotiating information exchange agreements. What impact will it have on the new negotiation that's underway?
Obviously, it will have a deleterious impact if India is seen in the international fora to be a country which breaches its solemn obligations under a treaty. It's obvious that it will have an adverse impact.
Now, it's not just that it will have an adverse impact on negotiations that are underway, and therefore these new countries may not negotiate treaties with you. I believe there is potentially an even bigger impact that could follow. If the government cannot guarantee confidentiality, then I'm told you will not be in a position to comply with the United States Foreign Account Tax Compliance Act, which you are required to comply with by the 31st of December. Let me finish my question. Let me finish the question. Let me finish the question, then answer it.
Sure.
And I'm told that if you cannot comply with the FATCA by the 31st of December, then starting 1st January, Indian financial institutions in America could become subject to sanctions. And more importantly and more worryingly, all remittances from America to India could become subject to 30% withholding tax. Can you confirm those?
You are absolutely right. If we are unable to have an in-cover treaty with them, the effect will be a withholding tax levy of 30%. And that is why we are worried that we should not be seen as an authority or a country which breaches it. And we will, as per the court's order today, in fact, I explained exactly what you said just now to the Supreme Court. The Supreme Court was of the view that we should explain our difficulties and whatever grievances we have in this process to the SIT, which is headed by 2 retired judges of the court. We will do so immediately to them and request them to make it a point to put it in their report, which has to go to court by November 30, that is the end of next month, so that even they understand what the position is, and maybe the Supreme Court may require to have a relook. A relook by the Supreme Court has not been prohibited by the order made today.
That's very interesting. You're hoping that when the SIT submits its report, the Supreme Court at that moment will have a relook at this issue. But however, let me, for the sake of the audience, spell out the consequences of what would happen if you fail to comply with the FATCA by the 31st of December. When it says that all remittances to India from America will become subject to withholding tax, it's not just remittances sent by an individual to his family that will become subject to 30% tax. It means all investment in India by American companies will become subject to 30% withholding tax. Is that right?
Yes, that is right.
And that means, sir, doesn't it, that if American companies want to invest in India, say $100, they actually have to put forward $130 because 30 will get removed by the withholding tax. So the cost of investing in India, the cost of investing by American companies in India will have gone up by an enormous 30% at one go. Am I right?
Are you asking me?
Yes, I am indeed. So I'm asking you for confirmation.
Yes, you are right. This adverse impact will happen. That is why we were worried. That is why we went to the court. The court said we will not examine all these issues because you have a right to go to the SIT. The SIT is the agent or the delegate of the Supreme Court, and we will therefore immediately place our position on this FATCA, as it is called, before the SIT and ask them to make a reference to the Supreme Court. And I must tell you, the Supreme Court recorded my statement today that we do not press this application as of now because we have liberty to go to the SIT.
All right, and you will raise this matter with the SIT and hope and pray that when the SIT...
Certainly.
And you will also hope and pray that when the SIT reports back to the Supreme Court, as you said a moment ago, will re-look at this matter.
I am confident that it will happen.
Now, moving beyond the impact on international treaties, moving beyond the horrifying impact that could happen on trade and investment with America, if the names of people who have legal accounts, money that they have legitimately earned, where there is no wrongdoing involved, if those names are revealed in public, will it not infringe on their right of privacy under Article 21?
You are absolutely right. In fact, in the judgment of Mr. Jethmalani, the main judgment of 2012, in this case, in para 76, records that right of privacy is a fundamental right, and people who have genuine accounts, who have done no wrongdoing, they have a right not to have their names disclosed in newspapers and flashed across TV screens. And it is for that reason that we are verifying all 627 accounts to shift separate the grain from the chaff, and the wrongdoings ought to be disclosed and not which are right doings.
Can I put this to you? In disregarding your arguments about double taxation avoidance treaties, in disregarding your argument about the impact on trade and investment from America, in disregarding your argument about Article 21 and breaching the right of privacy, has the Supreme Court been a little reckless, a little unwise?
See, again we go back to the basic question. The Supreme Court has not rejected a single argument. As I told you earlier, exchange of thoughts or exchange of arguments is not reflective of the court's judgment. Yesterday's judgment of the court is one line, namely adjourned to today at 10:30.
All right.
And today the court has recorded an order of SIT. It's completely wrong to say that any argument has been rejected.
I take your point that do not go by the obiter dicta of the Supreme Court judges and the Chief Justice in particular yesterday. Those don't constitute judgment.
Sorry, Karan. Sorry, in law, obiter dicta has a separate meaning. This is not even obiter. These are loud thoughts which can come to an individual, but ultimately what is penned down is the law.
Would you rather that the Supreme Court and the Chief Justice in particular had not indulged in these loud thoughts? A certain modicum of restraint and silence would have been more becoming of the Chief Justice of India rather than thinking aloud in this fashion.
I don't think it is fair to blame the Chief Justice of India or any judge for that matter on the bench or otherwise. These exchanges occur every day, normally in every case. It is just that reporters are present in this case in huge numbers and they seek to report every line as if it has been decided, or as if the court has damned a party.
Two quick questions before I end the interview. I want to come to one of the comments made by the Chief Justice, and I'm quoting him. Why are you trying to create a protective umbrella for these people? He seemed to suggest that by revealing the names, you would remove that umbrella. Now, Arun Jaitley, the finance minister, has said that actually if the names are revealed, where there is no prosecution evidence and no charge filed, foreign countries will stop cooperating. You said the same thing a moment ago. And that, he said, Mr. Jaitley said, would actually provide cover for the alleged offenders. So Mr. Jaitley's position and the so-called comments of the Chief Justice are the polar opposite of each other. Who, in your opinion, is correct? The Chief Justice in his loud thinking, or Mr. Jaitley in what he said in considered interviews?
I would say both have a right to express their views. I concur with the views of Mr. Jaitley, but I do not say that the Chief Justice has no right to have loud thinking. Every day when we appear in court, the judge may start by saying that I'm going to hold against you on this point, but after some time a court or a judge, by a process of reasoning and logic, may come around to our view. It happens every day. So let's not blame courts just because they have some loud thinking.
What you're saying is don't take seriously the loud thinking of judges in courts. They don't necessarily stand.
Exactly, exactly.
They don't necessarily
Either of judges or even of lawyers.
You know, it's a very sad conclusion we're coming to. What you're saying is don't take seriously the loud thinking of judges. They don't necessarily mean what they say. For laymen, that would be quite a shocking conclusion.
I don't think so, because judgments are delivered after due deliberation of the law, after due deliberation of the facts. This exchange of thoughts happened for 15 or 20 minutes without opening a single paper. It was just an exchange. The court said, why have you, etc., etc. So I'm not getting into technical details, but do not, for God's sake, go only by loud thinking, which seems to be the order of the day in all media reportings.
All right, Mr. Rohatgi, as Attorney General of India, I'm grateful to you for clarifying the situation. I'm even more grateful to you for pointing out officially the damning consequences that would follow if it is really deemed and established that India has breached the clauses of confidentiality, what that would mean for existing double taxation avoidance treaties, what it would mean for those we hope to negotiate, and most important of all, what it would mean for trade and investment with America. Thank you very much for talking to Headlines Today. Time for a break, but then the views of two senior Supreme Court lawyers, Harish Salve, who is sharply critical of the Supreme Court, and Prashant Bhushan, who is hugely encouraged by the Supreme Court's behavior.